Can I sue my bank or mortgage lender for harassing me to collect a debt? My name is Michael Wasylik. I'm a Florida foreclosure defense lawyer with Ricardo and Wasylik here in Florida, and together with my partner Jason Ricardo, we help people just like you overcome foreclosure and debt collection with dignity. The question I'm going to answer today is, can you sue your bank or mortgage lender if they're harassing you about a debt collection matter? Now, debt collection generally falls under two different laws in the state of Florida. One is the federal law passed by the U.S. government that governs how debt collectors are allowed to communicate with you in order to collect a debt. And secondly, there's a state law that also governs the way debt collectors and original creditors are allowed to communicate with you about your debt. And generally speaking, the number one question, the number one obstacle in suing a bank or mortgage lender is whether or not that bank or mortgage lender constitute a debt collector under federal law. Now, if they're the original lender, they usually will not. If they're not the original lender, they might. And we can tell in 90 to 95% of the time right away whether the people that are harassing you qualify as a debt collector. If they do, then you likely have a lawsuit for any type of illegal practice. If they don't, then you may not, and we'll figure out a way to tell whether or not you have a valid suit. But once we make that initial decision about whether or not you have a debt collector harassing you, we can help you analyze whether it makes sense, whether you have a claim under federal debt collection law, under state debt collection law for harassment by a debt collector. Now, there's a number of different things that federal and state law consider a violation that you're allowed to sue for. And both of those laws are often determined very broadly because they're consumer protection statutes. They're designed to prevent abuse, and so the courts are required to be expansive about how they include people in them, although their natural inclination is to kind of define things very narrowly and tightly. They're required to define certain things very broadly, which means more things tend to fall into those statutes than other statutes. So let me explain what I mean. Federal law prohibits any type of misleading, deceptive, or unfair practice or communication when someone is collecting a debt. So if you have a debt collector that is communicating with you and they're doing something that's lying about the amount of the debt or the status of the debt or who the debt is owed to, or any other type of misleading or deceptive information in a letter or a phone call, that is something that can lead to a violation. If they are abusive or harassing in the way they talk to you, for example, on the phone, if they threaten to arrest you, if they use profanity, if they call you, if they ring your phone off the hook with the purpose of annoying you so that you just pay them to go away. All of those things are potentially illegal under the federal statute. There are certain things that are barred under both federal and state law. So for example, let's say you know you've got a debt issue, you've hired a lawyer to handle that debt for you, and your lawyer has notified the lender or the creditor or the debt collector, listen, talk to me, I've got this covered, don't talk to my client, talk to me instead. If you've got an attorney who's willing to do that for you, and they contact you anyway, the lender, the debt collector contacts you anyway, if they do that, that is likely a violation of state law. It's also likely a violation of federal law, and that means you can sue for it. You may recover anywhere between a few $100s to what we call statutory damages of $1,000, which is like a civil penalty that you just get to keep, or if you have suffered some kind of actual damage as a result of debt collection efforts. Like, let's say they call you at work and they call you 10 times a day and you're not allowed to receive phone calls at work and you lose your job. Well, then you've got damages, and those are big damages that you can usually sue for. So if you have that type of situation, if you have a debt collector who's abusing you, harassing you, lying to you, or telling you something misleading about your loan, and you suffer damages from that, you have a right to sue, and you may recover money. You may wipe out the debt. You may get your negative credit reporting deleted from the account. There's all kinds of things we can do for you if you've got that type of claim. So if a debt collector is harassing you, abusing you, lying to you, or if you're not sure if any of those things are happening, if you think that a debt collector who's irritating you may be doing one of those things, if you're not sure, if you get a letter and you don't know whether they have violated federal law, give us a call, ask us. We guarantee it's not a waste of your time. A free 30-minute consultation, a free 30-minute strategy session with one of our lawyers we're guaranteeing to give you more clarity, more information, more certainty about what your next steps are and whether you have some kind of claim against a debt collector who's harassing you or abusing you. So give us a call. The number is 352-567-3173. That's 352-567-3173. Now, Jason and I are in court a lot, so we have a limited number of appointments. They fill up fast because there's a lot of people wanting to talk to us. So if you're gonna call now. Call as soon as possible so that we can get you that slot as early as possible to talk to one of our lawyers. Be sure to mention when you call this video about, can I sue my bank for harassing me about debt collection? And we'll give you that free 30-minute appointment to talk to you about that. My partner Jason and I are looking forward to talking to you. Thank you for watching this video, and I will see you on the next one.